All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here in our case number CV210260, Dekutoski versus Dekutoski. Did I say that right?
Yeah.
Yeah? Okay. All right. Well, I get points for that. Each side has 20 minutes to present their argument. The appellant may reserve time for rebuttal. I ask you do that yourself. So there's a clock on the other side, and just keep that in mind, and you can say, I'm keeping this amount for a rebuttal, but we're not going to stop you and say you might want to sit down so you have a rebuttal. Our proceedings are being audio and video recorded today, so please introduce yourself and your client at the start. We've read the briefs, have discussed the case in conference this morning, and are familiar with the arguments raised. So I would ask that you keep that in mind as well as you argue. So with that, counsel, you may proceed.
Thank you, Your Honor. I'm going to keep my opening comments as brief and concise as our briefs, and then reserve the remaining time for rebuttal. We have two very narrow and focused issues. One is the entry of the decree and use of Rule 78 to resolve factual disputes, which is prohibited by the rule and the case law applying it. United Bank versus Allen was a good reference point because it says the rules prohibit its use for the purpose of resolving disagreements over the substance of a judgment or decree and any related agreement. So once we filed our objection to the notice of lodging of the decree back in August, which incidentally was the notice of lodging was filed soon after appellant's attorney.
Could you repeat the name of that case that you cited for me?
Pardon?
The case that you just cited?
Yeah, it's in our opening brief. United Bank versus Allen, 805 Pacific 2nd, 1012 at 1018.
Okay.
And excuse my voice, I had COVID in August, and it damaged my vocal cords, which are still on the end. So if I say a word that you don't hear, please let me know.
Okay.
Because it goes in and out.
Could you specify for me the factual disputes that wife allegedly sought to resolve at that time?
Well, if you notice in the notice of lodging, they actually say, we're doing this to bring to the court's attention outstanding issues. Well, how can you have...
Is there any specific factual dispute, though, that you are pointing to as wife having sought to resolve?
Oh my gosh, in our opening brief, we laid out in great detail.
So in the filing in the trial court that you are referencing, what specific factual dispute did the wife seek to resolve in that filing, seeking reentry of the decree?
Well, they never referenced that. They just lodged the decree and they said they were doing it to bring to the court's attention outstanding factual issues. And in our objection, I think it was on August 31st of that year, we laid out, 5 or 6 pages of what we believe to be wrong factually with the decree that was lodged. There was never any sign.
I understand that husband had some factual disputes, or at least some disputes, but you are saying that the reason the reentry of this decree was problematic is because wife sought to resolve factual disputes. And I'm trying to get at, what were they?
They never said in their notice of lodging.
Okay, all right. Go.
They never said anywhere. They just claimed they existed. So, once all the other procedural machinations that occurred after that, really were unnecessary, because the trial judge, Judge Dekutoski, as soon as that notice or our objection was filed, she just said, look, there's a lot outstanding here that the parties don't agree on. So we can't enter a decree because there's been no adjudication. It's not like someone's entering a decree based on final trial rulings or a signed settlement agreement. But they tried to use the Rule 78 process as a way of resolving what they alleged were factual disputes, which they never specified. So they must have believed some had existed at the time they filed the notice of lodging, because they said they existed, but they didn't specify what they were. So as soon as our objection was filed, which was highly detailed, Judge Dekutoski should have said, okay, clearly there's not agreement here, and there hasn't been a trial, so it's not like they're trying to enter a form of decree that was based on my trial rulings. We have to stop and set this thing for trial.
Counsel, doesn't that defeat the purpose of having an arbitration? I mean, your client doesn't deny that an arbitration took place, correct?
Not a valid one.
Okay, I understand your arguments about that, but an arbitration took place. So if you can just blow up an arbitration because you claim you didn't understand the difference between arbitration and mediation, what does that do to all the arbitration enforceability rules?
It's important to note that in order for that arbitration to be valid, certain prerequisites have to be met, and they weren't here, which is detailed in our briefs. But the arbitrator's rulings, the quote-unquote arbitrator's rulings, although significant financially, were limited to issues that the proposed decree went well beyond in terms of addressing many financial issues. So we're not trying to blow up the arbitrator's ruling. First, we're saying the arbitrator's ruling was invalid due to a lack of an arbitration agreement, which the arbitrator admitted in a letter to counsel saying, oh, after the first quote-unquote arbitration hearing, said, geez, I haven't sent you guys an agreement to arbitrate. And here it is after the fact. So we're not trying to blow up the process of arbitration, but it has to comply with the statutory requisites.
So in your opinion, counsel, your client's and your client's former counsel's signature to a Rule 69 settlement agreement that specifically states, I think it says, in the event the parties cannot agree, Barry Brody shall arbitrate the dispute. And then additional provisions that state similar.
Well,
that is not an agreement to arbitrate?
That's not quite what the arbitration agreement says.
No, I'm talking about the Rule 69 settlement agreement.
Well, but you're saying part and parcel of that is an arbitration agreement.
Well, that is an arbitration agreement. How is that not an arbitration agreement?
It
It's
is.
an agreement.
It is.
Let's take it in parts. Okay, it is.
Yeah, but let's apply what it says. It says, in the event of a dispute with respect to a term of the settlement or memorialization of a term of settlement into final documents, the dispute shall be submitted to Barry Brody in arbitration.
Right. But why don't we just stop at for term of settlement and not worry about the disjunctive kicker?
Right.
How is that not this case?
It is, and we're saying the arbitrator exceeded his authority. He wasn't allowed to adjudicate factual disputes. He was supposed to go back to the
Terms.
Yeah.
Terms of the...
Not not factual disputes, just how they will be memorialized.
Well, what do you mean by factual disputes? Brody was hired, from what I understand, to catalog and facilitate an agreement on the division of property and debt, right?
As a mediator, yes.
Okay, so now we're talking about beyond that, and so the second, I guess, was there, how long after the mediation did the arbitration happen?
I think it was about 4 months. The initial handwritten agreement was in March of that year, and I believe Mr. Brody, when asked to possibly arbitrate things, that's when you get in a gray area. It's always dangerous when a mediator serves as the arbitrator. And there need to be clear lines about those rules. But our point is, if you look at the arbitration rulings, you'll see he was asked to address things above and beyond the terms of the mediated agreement.
I'm still not seeing that, counsel. It says, in the event of a dispute with respect to a term of settlement or memorialization of a term of settlement. So that's what your disjunctive says. So you have, okay, so how we've documented it on one hand, and the substance of the document on the other hand. And those are both subject to arbitration. How is that an exceeding of the scope by Mr. Brody?
Because
to address those terms.
Simply addressing those terms is supposed to be based on what they did in the past, not new factual findings by the arbitrator.
So they could only arbitrate what had been already settled?
Yeah, to make sure it's properly memorialized, and that's what it says here. It doesn't say.
There's an injunction there. I don't accept that proposition because there's a disjunctive there. Term of the settlement subject to arbitration, memorialization subject to arbitration. So you're saying you can only arbitrate the memorialization.
No,
that's not what the document says.
No, I agree with it, can arbitrate the terms, but we're talking about resolving maybe some disputes over how something should be worded to memorialize the agreements that they've reached, not to go beyond making sure that a term property memorializes that agreement and start making new factual findings on new issues raised.
But isn't that the purpose of arbitration? I'm sorry.
No, I mean, I was just going to say, what's the difference between mediation and arbitration? Are we saying that arbitrators can only answer questions of law or can only act upon findings of fact rendered after a bench trial or an evidentiary hearing? I mean, that's not what an arbitrator is. I mean, I'm an arbitrator sometimes in the community for small cases, and I'm asked all the time to resolve what I think you're calling questions of fact, which is, I don't know, who had something, where should it go, but you're saying that that's just off the menu for an arbitrator.
No. Certainly an arbitrator can do that if the parties agree that.
Well, here's what the parties agreed to. In the event the parties cannot agree, Barry Brody shall arbitrate the dispute, hard stop. What about that?
What I have here, I have a different quote.
There's another one, in the event of a dispute with respect to a term. Is that what you're talking about?
Yeah,
we can reach that one, but
that's in the final mediated agreement.
And the other one is not, that general statement?
No, so their agreement limits the scope of his authority.
Okay, so let's talk to this second one. In the event of, so you're saying that doesn't exist, in the event the parties cannot agree, Barry Bodie shall arbitrate.
I don't say it doesn't exist, Judge.
Well, you represented the court. I just asked you, is it in that document?
Yeah, I said his authority is limited in that document.
You said what?
His authority is limited in that document.
Okay, let's put that aside.
Okay.
Do the words, let's just start this. Does it say anywhere in there, generally, if the parties cannot agree that Barry Bodie shall arbitrate?
Yeah, it says disputes about the memorialization of a term of settlement shall be submitted to Barry Bodie for arbitration.
Okay, so you're talking about the sentence, in the event of a dispute with respect to a term of settlement or the memorialization of a term of settlement into a document, comma, Barry Bodie shall arbitrate the dispute. Is that what you're focused on?
Yes.
And that is, as I understand it, the only mention of Bodie or arbitration in the Rule 69 agreement.
Yes.
So I take issue with that. I have that agreement up in front of me, and at the top of page 2, it is in a paragraph numbered 5, the parties shall agree on the division of personal property based upon the spreadsheet of November 8, 2018. In the event the parties cannot agree, Barry Bodie shall arbitrate the dispute. That is the language that Judge Weinsweg read a couple of times now, and that you have suggested was not contained in that agreement. Could you help me out with that?
Yeah, I had the parties March 18, 2019 mediated agreement states at paragraph 18, and that's where my quote comes from.
That wasn't Judge Perkins' question.
I guess my point is both are contained in this agreement, at least what I have in front of me.
Yes.
And so it was incorrect to suggest to Judge Weinsweg that the language that he read stating, in the event the parties cannot agree, Barry Bodie shall arbitrate the dispute. In fact, that language is tied specifically to the division of personal property.
Yes.
Which was going to be my next question. All right,
May I reserve the rest of my time, Your Honor?
you may.
Thank you. Thank you. Thank you.
Chris Banishewski on behalf of Sean Dekutoski. Thank you, Your Honors. I'd first like to talk about our argument that the appeal is untimely. And there's really two aspects to that position. First, the decree that was entered on March 18, 2021 merely incorporated several final orders of the Superior Court. And those are the final minute entry orders that we identify in our brief. It's the April 24th, 2020 minute entry, the August 5th, 2020 minute entry, and the December 24th, 2020 minute entry. All of those orders became final because they all included Rule 78C language.
Counsel, Rule 78C talks about the resolution globally of an entire matter. So if and you just cited multiple entries. So I disagree with the fact that, or with the proposition that inclusion or mere inclusion of a Rule 78C language or certification is effective in the face of outstanding issues.
Well, it was because they kept making motions for reconsideration and motions to correct the record and motions.
One of which was well taken. I mean, you agree with me that there was a withdrawal, right? And then because of the objection, and then a circling back.
Well, it wasn't withdrawn.
Vacating.
It wasn't withdrawn because of the substance.
But it
of the
was
objection.
vacated.
It was vacated.
Okay.
So that's why we then keep having then additional final Rule 78C. And I guess so then the final one is the December 24th, 2020. And that one is one that resolved all of the issues. And it was then after that we filed the second, or lodged the notice of the second decree to make, because there was still no language actually divorcing the parties at that point. And so we just needed that decree to say, yes, the parties are divorced, but all of the underlying issues that resulted in that decree had been resolved by the December 24th, 2020 minute entry that incorporated the parties' Rule 69 settlement agreement, the original arbitration award, and the supplemental arbitration award.
And husband filed a notice of appeal that would be timely from that December.
Not from that December minute entry, only from the decree that was ultimately entered.
Well, he
Okay, so
filed two notices of appeal.
Yes.
One was on January 22nd, 2021.
Yes, and that one was vacated.
Right, but it was
Yes.
vacated because this court didn't have jurisdiction because there was no decree. So I mean, the jurisdictional argument seems to kind of circle back in on itself multiple times. And I understand your argument. I'm not sure that I agree with it. I think your time might be better spent on the other issues that we have in front of us.
Well, then let me move to the second aspect of the untimely argument that just relates to the issue about the authority of the arbitrator, okay? Because what happened, it's almost like it's double statute of limitations. Because in order to, following the first arbitration, there was an award, okay? And under ARS 12-3023, husband had 90 days to file a motion with the Superior Court to vacate that award, okay? He never did that.
Can you give me a record site for that? Index of record, or you know what? Can you look at that and then you keep going?
For which exactly are you asking?
For that, the document, the 60 days, whatever would have kicked off that 60 days?
Yes, that would have been the original award, and I think the date of that was May
14th.
May 4th, 2019, yes.
That is record 20.
Yeah.
IR 20, okay. Okay, so let's go to, if unless you want to spend more time, it's your time, the arbitration issues.
Okay, sure. Let's talk about the Rule 78 issue then. And Judge Perkins, you hit the nail on the head with your question. He takes one sentence out of the original notice of lodging the decree where wife says, wife lodges this decree of dissolution of marriage to bring any issues between the parties to the court for final review and determination. And he takes that and he makes a whole argument out of it without realizing that although that statement was made, wife didn't request and the court did not rule on any substantive factual issues when the court entered that original decree. The record does not support that, and not in either of their briefs do they identify any such issue. And they can't identify it because there wasn't any. And then we get into the whole issue of that language only dealt with the previous decree that got vacated, and then when we lodged the second notice for the final decree, that language wasn't in there, and again, there were no factual issues or substantive issues that were decided. The decree merely incorporated the Rule 69 agreement, the original award, and the supplemental award. And there were no other issues raised, there were no other issues discussed, and that decree was entered. Unless there's any other questions on that issue?
What about your colleague's argument that the arbitration clause is unenforceable because his client lacked an understanding or information about the agreement?
Well, first of all, there's nothing in 12-3023 saying it's not one of the enumerated reasons for which you can vacate an arbitration award is that, oh, my client didn't understand the difference between mediation and arbitration.
Right, that would
So I don't think
go to the
that's-
arbitration clause, is what I'm saying. The
Yeah.
enforceability of the clause itself.
Yeah, and as the court has already pointed out, there were two different arbitration provisions in the Rule 69 agreement. And when you take both of those together to suggest that the arbitrator's authority was limited somehow only to deciphering the wording of the Rule 69 agreement that he was already a part of makes no sense. I mean, why would you have to have an arbitration hearing just to decide what the terms meant? That just doesn't make any sense. The arbitration hearing was specifically if they had an issue with respect to the division of property, which was really the only issue that was still alive at that point in time was the division of really three pieces of property: the bed frame, the mattress, and the nightstand. I mean, that was it. And there was a dispute over that, and Barry Brody made a decision on that, and that became final. And so...
And counsel, there in the briefing, and you address this, there's an argument that the notice wasn't effective. Was notice sent? I mean, I know that husband's prior counsel shows up to the arbitration.
Yeah.
What was a notice sent?
Yes, there was so after the award was entered, they were having this one issue over the furniture, and then the other issues really dealt with the fact that the husband wasn't following the Rule 69 agreement, and so that's why my partner got a hold of the arbitrator, got a hold of opposing counsel, said, hey, we need to talk about these issues, we need to resolve these issues. There was a phone conference. During that phone conference, the arbitration was set, and Barry Brody then followed up with a letter to both counsel indicating, hey, here's the date that we're going to have the arbitration, date, time, and any other specifics. I believe that letter is in the record. I don't have the site off the top of my head, but that notice was given to both counsel, and
I assume also that it was given with sufficient lead out pursuant to the statute.
it was. Yes, it was, yes.
Is there anything in the Rule 69 agreement that requires a longer period of lead out, like a 4-week lead out period?
No, there's nothing in there that I've seen.
Because I
Anyway.
didn't see it either.
Yeah. So, I mean, counsel had notice, second, there's nothing in the record to suggest that counsel didn't provide that information to her client. There's no affidavit, there's no hearing testimony, there's nothing to suggest that didn't happen.
And that's significant because why? Lawyers act in a representative capacity, definitionally.
Yes, exactly. I mean, I think notice to your counsel is notice to the client unless, there's some specific evidence that, hey, a specific circumstance, maybe my lawyer passed away, I didn't get the information, they retired, he quit on me, I didn't pass the information. There's nothing like that in this record.
And theoretically, father would have a claim, a malpractice claim.
Right.
Go to the bar. That seems like it's serious enough to get some
Precisely.
real discipline.
Yeah.
Go ahead.
I think the court has already dealt with the arbitration provisions. I think there's the one that's specific in paragraph 5, and then the paragraph 17 one seems to me to be a catch-all of, look, if there's any other issues regarding any of the terms, or about one of the terms of the settlement agreement, then, hey, we're going to send it back to Barry Brody to have him decide the issue. So I think that language is broad enough, and it's not as limited as counsel suggests that it couldn't deal with substantive issues. Those are the issues. So unless there's any other questions.
I don't.
Okay.
Doesn't look like it. Thank you very much.
Thank you.
Mr. Banaszewski. Counsel, Mr. Mio.
Thank you, Your Honor.
Did I pronounce it right, by the way?
It's a short E. No.
Mel. Okay.
Don't ask me why.
Well, people mess up my name.
My grandfather couldn't even tell me.
Right.
Anyway, I want to point out that the issue leading to the entry of the April decree, the final decree, was the fact that there was a lack of a signed minute entry. The judge's rulings in the preceding December weren't signed. And we pointed out to counsel, hey, we need to have something signed here. Under the rule, it's required. And we brought that up to them in February. At first, they said, no, we don't need any more. The December decree is enough, or the December minute entry is enough. And then within a month or two, they lodged a request and a proposed form of minute entry for the judge to sign. And we finally got a signed decree. The original decree was entered by Judge Dekutoski by mistake. And Mr. Banaszewski just said that it was entered based on his believing he was resolving the issues. But as he later admitted, it was entered by mistake without even knowing, our objection had been filed. He entered the decree in September, and we contacted his JA. Well, that's beyond the scope of the record. Anyway, that decree did not resolve any issues. It was entered without realizing we had filed an objection, and that's why it was vacated. I believe that the statutes governing arbitration point out that unless the arbitrator points out clearly to the parties, especially from moving from the role of mediator to arbitrator, they explain the difference. And
You're saying the statutes require that?
yeah, and the JAM periodicals as well.
I saw those citations. I did not see any citations in your briefing to a statutory requirement for this sort of admonishment.
I believe our reply brief touched on it, but I could be incorrect.
And who's responsible to give that? I mean, if you have a lawyer, that's...
No, the arbitrator has it send it out to everybody.
Oh, it's a document. Is it a form?
Yeah, well, not a form, but they say that here's what you're supposed to do as an arbitrator. And they even touch on it's especially important to do it when you're moving from mediator to arbitrator, which, by the way, is discouraged generally.
You're talking about the JAM.
Yeah.
That's what you're talking about right now.
Oh,
Yeah.
okay. Not a statute, not the legislature.
I believe our reply brief did touch on it, but if I'm mistaken, I apologize.
I mean, is it the rules of arbitration or... Wait, well, I'll look. Okay, go ahead.
By the way, my colleague mentioned that the only outstanding issues addressed by the arbitrator was a bed and a headboard. Both of these parties are doctors. They're probably in the top 1% earning of the population. This bedroom set, which was far more than a bed and a headboard, was worth over $25,000. So it was kind of an important issue. About our time to object to an arbitrator's ruling, the arbitrator issued 2 rulings. So our point, which Judge Ostrowski accepted.
And I'm going to let you finish this point, and then your time is up.
Okay. I'm sorry, I just lost my train of thought. Our point was that the 90 days began to run after the second ruling, and we filed our objection within that 90 days. Thank you.
All right, well, thank you both, counsel, for your arguments. We very much appreciate it. We will take the matter under advisement, have a decision in due course, and with that, we are adjourned.